Well, hello everyone. It's a real privilege to be able to talk to you today about a topic that is very dear to my heart, and that is artificial intelligence in courts. I have about a 15-minute presentation, and I understand there will be a Q&A afterwards. So here we go. My research question here is whether artificial intelligence can support judicial quality and efficiency, and mainly also about how. And this is just my personal profile, if you're interested. And so let's move to my topics. There are 4 of them. The first one is that I talk a little bit about AI, then about some problems that AI has been known to cause, and also some solutions to it. The third talk is about one of the solutions, that is ethical principles for the use of AI. And finally, some challenges for courts if they want to leverage the power of AI. And at the bottom of the screen, you see the link to my article about the topic. So, artificial intelligence. At the moment, we distinguish about 3 different kinds of artificial intelligence. The early one is machine learning. Machine learning needs to be trained for a purpose. It is an algorithm that will do something for you, and if you train it properly, it can do that correctly. And the next level up actually is deep learning, where the algorithm itself learns from the data that you feed it. And the latest generation is called generative AI, and that does all those things, but it produces content from the data that it's been fed. So that is the new kid on the block, let's put it that way. What actually does AI do? And you've understood from what I just told you that what it does is data extraction, and it finds identical patterns and creates either a learning or even content from that. So that's the way it can do drafting documents. And what we see now is that AI is not a separate system that you introduce. It is baked in a lot of things that we do. And the main job it does is analytics from the identical patterns, tell you, draw conclusions from those patterns. This is the very simple way of explaining it. If you are a lawyer in the US and you can pay LexisNexis, you can get legal analytics, for instance, as you see here, citations analysis, compare forums for you, and if you have a full set of algorithms that you can draw into, you also have judge profiles. The workings of these systems are a trade secret, so we don't know how these algorithms actually work. Looking at use in the courts in the US, when I want to understand more about how technology is being used, I always look at the courts in the US because they are further developed than we in Europe tend to be. So AI in use in the courts in Europe, in the US, sorry. Some states already use chat boxes that have AI baked into them. And what that does is it relieves the court staff from answering questions on the phone. So they're FAQs on lots of topics. The next tool that is being used is sentencing algorithms. I will show you an example of how that works later. It's guidance for judges who have to decide on sentencing defendants. Then there is translations, and what I'm told by the court management in the US is that they do not use it for the courtroom, but only for customer service. Then there is data extraction. The courts say that they will not let outsiders use their data. They have strict control on the data that they produce themselves. And then there is speech to text that is being used at a low level. And the difficulty with speech to text in the US is still recognizing all those different accents. Some examples about ChatGPT, which is a generative AI. What can it do? One of the tests that I did with it is what asked ChatGPT, what do you know about Dory Reiling? And I can recommend that you do that too and see what happens if you do that. Because I asked ChatGPT, and this is what it came up with. It came up with other stuff that was okay. I had won a Lifetime Achievement Award in 2015. No such thing. And an Info Security Award, I also did not get that. And I co-authored a book that I'd never heard of. So ChatGPT, if you want to put it, mildly, it fabulates, because it has no idea about content. It just puts words that seem to belong together. Another one, this is actually from a lawyer's assessment test, where the ChatGPT was asked, name 3 noteworthy opinions by Ruth Bader Ginsburg. And it went fine, but then oddly, it claimed that she wrote a dissent for Obergefell and Hodges. That's the one on same-sex marriage. And of course, she was for it and not against it. So this was really strange. Other things that went wrong. This is a famous case from New York City. Stephen Schwartz and Peter LaDuca submitted a brief that had non-existent judicial opinions and fake quoting it. And they had just submitted it, and then the court checked those opinions and found out they didn't exist. So the federal judge in charge of this case tossed the lawsuit out and issued the lawyers with a fine. And what I've seen since is that courts in the US tend to demand that lawyers certify that they have used forms of AI and that they have actually checked them for correctness. And if they haven't, they will be punished. So something else, what AI found hard and why, to understand a little more about how it works. It has difficulty recognizing, or forms of it have recognizing black faces in facial recognition. And when facial recognition is used for identification purposes, and if it cannot recognize your ID, it may be difficult for you to take part in an exam or things like that. And that's because the algorithm was trained on white faces. Now, this is something that can happen if the people who do the training do not understand that training just on white faces is going to give you problems with faces that are a different color. And another one, and that is also a famous one, was the Google recruitment algorithm that could never find suitable women for jobs because it had been trained just on Google staff data. Most of them were men, and so somehow the gender was a statistic that the algorithm didn't like. And so those are the things that we found. Of course, there are maybe things we don't find. So back to the sentencing algorithm. I participated in a project by the European Commission on the Efficiency of Justice, who did an early form of guidance called the Ethical Principles on the Use of AI in Courts and Justice Institutions. And one of the principles there is non-discrimination. So here we actually have an example of an algorithm that gives a high risk to someone with a black face and a low risk with someone with a white face, which is of course unacceptable because it is discrimination. We consider a distinction like that unfair. Different people are treated unfairly, and this is something that is actually, it is in use. The citation is at the bottom of the screen. You can find the article. We did a very thorough research on how this produces results that are not right. This is the name of the system. It's called COMPASS, Correctional Offender Management Profiling for Alternative Sanctions. So it's about deciding whether to release someone on parole, whether they have to stay in custody after they've been arrested, things like that. And why does this happen? It could be in the algorithm. It could be in how the algorithm was designed. The programmer could be the person with, let's say, a limited model in their heads. It could be lack of data. You need a lot of data for something to be recognized. The laws could be biased and then populate the databases that are used with biased information. It could also be that the judges who apply the laws are biased and therefore produce data that are biased, and therefore the algorithm cannot do its job properly. So this also points in the direction of what needs to be done in order to make the use of algorithms in courts actually work. But there is another principle, and this, I think, to me is the most important principle. Principle 5 is about artificial intelligence that should stay under user control. Now, when we wrote the ethical principles, that was in the early days. But right now, this is the consensus, that whatever happens, AI should stay under user control. And what does that mean? It means that the computer should not decide on its own. The case law in Europe at the moment is that, yes, there can be automated decision-making, but there should always be recourse to a human authority, usually a judge. So the users of the AI, the judges, the lawyers, whoever, should understand what the AI does in order to be able to decide whether they want to use the result. And also, not only should they understand, but they are the ones who can decide what they want to do with the AI result. So the consensus about using AI in courts is becoming clearer. And by now, there's a whole host of judicial guidance from various judicial organizations. This one is from the UK courts and tribunals. They say, and this is more or less, it reflects what the ethical principle said, you must understand how it works. Be aware that there may be bias. Be aware that court tribunal users also may have used AI tools. So and of course, maintain confidentiality and privacy of your data. And your data need to be secure. So this is the consensus at the moment in most forms of guidance. And another thing, I follow the debate, and by now, if you will remember that some years ago, predictive justice was the buzzword. But right now, in the discourse, predictive justice has completely gone. So predictive justice, I think, is actually effectively dead. And that's because we understand the risks and the pitfalls much better. I think this is about my final slide. I've produced an AI to-do list for courts. What do courts need to do if they want to use AI correctly? They need to control the design of their algorithms, how they are developed, and they have to make sure that they work correctly as they are being used. So that's a huge new task for courts. They are responsible for the correct workings of their algorithms. And what they're also responsible for is the legal source input, the data. The data have to be correct, they have to be secured, and there have to be enough data for the AI to be able to draw conclusions. And that means that probably we should start making machine processable judgments for the AI to work with. So those are big jobs, but these are what courts really need to do if they want to use AI safely and responsibly. And that was, so final conclusions, back to the research question. Can AI support judicial quality and efficiency? Yes, it can, but judiciaries really need to deal with the challenges I just sketched for you. This will need changes in most judiciaries who are geared to processing cases and producing paper documents. So the governance needs to change, and so do the work processes. And those are my conclusions on whether AI can support judicial quality and efficiency. And I look forward to the discussion we're going to have, and I'm happy to answer your questions in the Q&A.